Hello friends, in the series on the income tax cases, today we will discuss a very important issue which is regarding the transfer of the cases and which is mostly because of the search and seizure on one party, and if in that search if any documents related to the other party are found, then it is the usual practice of the revenue that the cases of the other parties are also transferred to the central circle in which the case of the searched assessee is being done. The main logic for the transfer of these cases is being given by the revenue is that for the proper assessment of that assessee and for the coordinated investigation, this transfer is being done. The assessee main plea for challenging these type of transfer is that there are logistical difficulties for the assessee, like going from one place to another place, and the inconvenience is there to the assessee when his case is transferred from one place to the other. So whether in these circumstances the plea of the assessee will work or the plea of the department will work, this is a matter of dispute. And what is the viewpoint of the courts in this regard, we will discuss in the case of Gulati, Mark Gulati versus Principal Commissioner of Income Tax and others, and this case has been reported in 471 ITR at page number 96. The date of the judgment is 7th May 2024. In the present case, there was a search on the Jet Group in Karnal, and in that search some documents were found related to the party Gulati and Mark Gulati, which were in Delhi. The notice under section 131 subsection 1A was sent to them, and in compliance to that notices they supplied the information to the Deputy Commissioner, and in that reply it was found that there were some loan transactions between the searched party and the assessee. After that, the cases of the assessees were transferred from Delhi to Karnal after passing the order under section 127 and after giving them an opportunity of being heard. And when the assessee raised the objections, even after the objections filed by the assessee, though those objections were not found tenable and the case was transferred from Delhi to Karnal, the assessee filed a writ petition in Delhi High Court against these transfers, and the main contention of the assessee was that in the present case the transfer which has been done from Delhi to Karnal is not bona fide and there is no live link between the searched assessee and the assessee. When this petition was being heard by Delhi High Court said that in the present case there is no merit in the contention of the assessee because there were some transactions related to the assessee and the searched party. Delhi High Court in the present case said that in the present case the power has not been exercised in an arbitrary manner, in an irrational manner, and the power is not exercised without jurisdiction, and in the present case the power didn't suffer from any malified intentions of the revenue. The court said that there is no doubt that before transfer under section 127 the reasonable opportunity should be given to the assessee, and whenever the objections are disposed of the assessee there should be due application of mind. From the present facts and circumstances of the case, it can be safely said that the reasons are not capricious or malified and the transfer has been done as per the objectives of the act. The court further said that in the present case, it is a settled law that when there is a conflict between the coordinated investigation by the revenue and the logistic difficulties faced by the assessee or the inconvenience caused by the assessee, then the coordinated investigation should take the precedence before the logistic difficulties and convenience of the assessee. In this matter, it is also an important point nowadays that whenever the assessments are done in a e-proceeding manner, the notices are uploaded on the portal, the assessee can submit the submissions online. So it cannot be said that the assessee has to travel a lot before submitting the documents. So in the nutshell, the court gave its verdict that coordinated investigation is a good ground for transfer of cases from one jurisdiction to another. At the end of this video, once again I am repeating the name of the case. The name of the case is Gulati, Mark Gulati versus Principal Commissioner of Income Tax and others, and this case has been reported in 471 ITR at page number 96. The date of the judgment is 7th May 2024. Thank you, friends.